So my paper presents an overview of some of the achievements of the ICTR in advancing the right to a fair trial, and on some of the areas where there's room for improvement, with a particular reference to the length of trials and related issues. So starting then with the positive impact of the ICTR in promoting respect for fair trial rights, it's my view that holding trials at all on the international level is itself a positive development. Human rights law, as you know, is not prescriptive. It doesn't tell domestic states how best to ensure that the right to a fair trial is ensured in their judicial system. And before the establishment of the ICTY and the ICTR, the only time that we really saw convergence between criminal law and human rights law was in those rare occasions, those occasions where an individual applicant brought a claim saying that their human rights had been breached in the domestic criminal justice system, and ex post facto claiming for a breach of their rights. So international criminal procedure now represents a model of day-to-day practice, and this practice is frequently declared to represent the highest standards of fairness. On the flip side of that, of course, is a heavy obligation to make sure that international criminal procedure does in fact truly illustrate the highest standards of fairness. And the danger of doing otherwise was illustrated after 9/11, where a decision in Tadic, which hasn't been followed in later proceedings and can in my view really be seen as an outlier, was used as a justification for the use of anonymous witnesses in military commissions. So we can see the danger in maybe moving away from the highest standards of fairness, because the US was able to say, well look, the ICTY said it's okay to use anonymous witnesses, so why can't we? The second positive point on the ICTR's practice is the centrality of the rights of the accused to proceedings. And there are literally hundreds of references from the case law stating things like, you know, it's imperative that the rights of the accused are respected at all stages of proceedings, that the services to the principles of due process and fairness are core to the tribunal's work, the need to grant the highest standards of due process and fairness is imperative to the work of the ICTR, the legitimacy of its judgments, and so forth. And just to give an example, this is from Judge Dolenk in Natagarura. He said, "We cannot lose sight of the effect of the tribunal's jurisprudence on international and national guarantees to a fair trial. If the international tribunals fail to provide a model of fairness, we send the wrong message to other courts." So my third point on the positive developments of the ICTR, I want to specifically mention the right to be present at trial. And the ICTR has really developed this right and has staunchly defended it. So in Sigurani Razo, the appeals chamber first interpreted the right of the accused to be present at trial as meaning physical presence at trial. And the context of that case was there was a witness who was unable to travel to Arusha, and so it was proposed that the chamber, the prosecution counsel and the defence counsel would all travel to The Hague to hear that witness's testimony, but the accused hadn't been granted a visa for travel, so it was suggested that he could follow proceedings via video link. Now the appeals chamber overturned that and said that the right to be present at trial means the right to be physically present at trial, and they read this into the French version of the statute, which says which seems to suggest that physical presence is required. They read it into the fact that national, international and regional human rights organisations have interpreted this right to be present at trial as meaning physical presence at trial, and the fact that the statute and rules had no express provision on proceedings via video link. In any event, I mean, the reason for relocating the judges to The Hague to hear this particular witness's testimony was that they were afraid they might not be able to follow it by video link, which of course the same concern arose for the accused. So I think that was a good decision. And since that decision, chambers have really protected this right of the accused to be present at trial, particularly the appeals chambers. So there are examples where, for example, when the accused is ill and isn't able to be present at trial, rather than proceeding in the accused's absence. It's been held, no, we'll just adjourn proceedings until the accused is fit to be present at trial again. My fourth point on the successes of the ICTR in promoting fair trial rights centres on Rule 11 bis referrals and the rule's positive impact in Rwanda. I'm not going to dwell on this because it's been discussed at such length yesterday and today. But I just briefly want to recall, some of the criticisms that have been raised here today and that were raised by leading academics at the time of the first refusals to transfer to Rwanda. And this idea that, the ICTR was somehow neo-colonial or was setting impossible standards. And I was reminded of Tom Frank's comment, response to critiques of his conception of fairness, where he said, well, look, there's no need to dash to protect every cultural practice as if it were the last white leopard. I really like this phrase. But the fact that Rwanda has been able to put these reforms in place, and I mean, kind of referring to what Phil asked earlier, the key point in the refusal to transfer case to Rwanda was this issue of the protection of defence witnesses, and that has now been addressed by the Rwandan judicial system. So I think that the fact that each case is taken on a case-by-case basis, that Rwanda has been able to put those reforms in place and effect transfer, shows that maybe some of those critiques were a little bit underestimated the capacity of Rwanda. And it suggests that the role of the ICTR in this regard is more of one of encouragement and support than this top-down imposition of impossible criteria that can't be in any way complied with by the domestic thing. So, and in the Rule 11 best practice, the tribunal willingly embraces a demonstrative function in showing domestic states how fair trials operate. So the inclusion of due process criteria in the Rule 11 bis rule is based on the principle that the same treatment should be afforded to the accused whether they're standing trial in Arusha or whether they're standing trial in Rwanda or anywhere else in the world. So in light of that demonstrative function, I think it's important or appropriate to turn to some distinct areas where some procedural reforms might enhance the rights of the accused before the ICTR. And as I said in my introduction, these are loosely based around the right to trial without undue delay. So turning first to the length taken to issue judgments, it has to be noted that there have been some notable advances in recent judgments in this respect, particularly in single accused trials before the ICTR. So Himana, the case closed in September 2011, summary judgment issued 2 months later in November 2011, and a written judgment released the following month. Nisabo Neimana, case closed on October 2011, judgment in May 2012. Karamera, Nagura and Patsy, the case ended in August 2011. I'm very pleased that 2 judges from the trial chamber are sitting here. And a summary judgment is issued in December 2011, so just, 4 months after the close of trial, and the full written judgment released in February 2012. So these are some positive developments. Unfortunately, some other cases have seen far bigger gaps between the close of trial and the issuance of the judgment. So in the Butara case, 2 years and 7 months. Government 2 case, 2 years and 11 months elapsed between the close of trial and the issuance of the trial judgment, in which 2 of the accused were actually acquitted, having spent more than 12 years in detention at the ICTR. The other 2 accused, just as a side point, were acquitted on appeal in 2013, having been in detention since 1999. Similarly, Kabiliji, one of the co-accused in the Bagasora trial, spent 11.5 years in custody before his acquittal in 2008, and in that case 18 months passed between the close of trial and the issuance of an oral summary judgment acquitting him and ordering his release. So the practice of issuing summaries first with the full judgment to follow became increasingly popular in the later years of the ICTR and has expedited the issuance of judgments in some of the cases mentioned at the outset. But we see in Bangor that it didn't really have that desired effect of wait of 18 months to find out that you're acquitted, and only then in summary born. Thank you. So while it's accepted that international criminal trials involve greater quantities of evidence than the regular criminal trials, the judges, of course, will have been present for the presentation of that evidence. They'll have been there for the prosecution and defence teams, will have summarised their positions in closing briefs and arguments. And chambers have a team of legal officers at their disposal that can, refresh their memory and provide legal briefs. So it's submitted that by the close of trial, judges should have a fairly good idea about whether they're inclined to acquit or find the defendant guilty or innocent on the charges in the indictment. And I think it's not unreasonable to suggest that judges could spend a few weeks intensely deliberating on the question of the guilt or innocence of the accused, delivers a summary judgment shortly after the close of trial, and then after following the verdict spent a few months drafting the final judgment, which would include a full analysis of the evidence and important findings on legal definitional issues. It seems to me that one of the main problems leading to the delay between the close of trial and issuance of judgment is that judges are sometimes quickly reassigned to sit on other benches in different cases. So that happened in Bangor and Government 2 as well. And that means that they become immersed in the new case and don't have the same amount of time to dedicate to the drafting of the judgment in the case they've just finished. Knowing that the judges in their case were busy with another case is of little reassurance to the acquitted person who spent a superfluous almost 3 years in detention waiting for judgments. So it's submitted that judges shouldn't be transferred to new cases until the judgment has been issued in their last case. And this would comport with jurisprudence from the European Court of Human Rights, which held that contracted states have a duty to organise their judicial systems to ensure the fullest compliance with Article 6. On the length of trials themselves, I'm just going to touch on this briefly because I'm slightly running out of time. It's difficult to point to a single reason for why trials are so long before the ICTR. I mean, in Caramera and Nigger and Patsy, we see all these exceptional events like the death of the co-accused Nazarera, the illness of Nigger and Patsy, the fact that a new chamber was assigned, so the trial had to be restarted after 2 years. So these are exceptional things, but a couple of themes that we see, I think one is the compliance with disclosure obligations causes a huge amount of delays. I mean, in Caramera there's something like 30 motions on non-disclosure, Bagasura and all, over 25 motions on prosecutorial non-disclosure. And in Bagasura, and this is a common theme, the trial chamber held the prosecution had failed to fulfil its disclosure obligations, and exhorted the prosecution to be more cooperative with defence counsel in general and with respect to disclosure in particular. So this is the common sort of response to a failure to comply with disclosure obligations, a sort of sanctioning, a reminder of the obligation to prosecution counsel, but it doesn't go beyond that to individual sanctioning, stay of proceedings, excluding the evidence at hand, or the more stringent sanctions that might actually encourage greater cooperation with the disclosure obligations. Another big issue is the joinder of trials. We see this in Butare, and we can talk about that maybe in questions. So I just want to wrap up this paper. How many minutes do I have? One, oh no, with the treatment of motions on the right to trial without undue delay, and an interesting phenomenon which I call the reverse application of the right to trial without undue delay. So in the first instance we have two examples. I can talk about them maybe afterwards in questions or so forth. That in Mugiraneza, where the accused alleged that his incarceration for 4.5 years infringed on his right to family life, and prejudice offered to the accused is one of the factors that the chamber has to look at. But the trial chamber said the defence has failed to show exactly how prejudice has been suffered. Now we know that the trials in the ICTR are temporarily removed from the time that the incidents took place, so it's admitted that for every passing month, you know, witnesses are going to die, memories are going to fade, and I think that once we can see that there has been a delay and that's not attributable to the defence, that it's attributable to one of the other parties, thank you, then the prejudice suffered shouldn't be an insurmountable barrier to cross. There's also some things on disclosure obligations, but I'll talk about that later. And on the, I'll just finish with this point, the reverse application of right to trial without undue delay. So in Nyaramashuko and all, the question came up about whether the trial should proceed with the substitute judge. And 5 of the 6 co-accused said that they didn't want that to happen, they'd rather have a restart of the trial. And this was understandable because a lot of the witnesses had been heard in closed session, which meant that the new replacement judge would have to decide on their credibility on the basis of the transcript as opposed to actually seeing their testimony, which hadn't been recorded. And the chamber held, well look, you've got a right to a trial without undue delay, so we're going to proceed in this other manner with the substitute judge against your wishes. So I think it's an interesting thing, the sort of application of the rights against the accused. I'm going to leave it at that point, and I look forward to any questions and comments at the end. Thank you.